Morning, members. We have a quorum, and this is the appointed time, 10:45. I call the meeting to order. Let me first invite the administration to join us. In response to members' views raised last time, they have given us a response paper. Paper number CP bracket 1291/1314 bracket 01. And I declare that I own properties and my employer provides advice in relation to taxation issues. Mr. Andrew Lang, I have properties and the companies I own also own properties. Mr. Chen Kam Lam, I own properties. And I may engage in the property transactions. Mr. Kenneth Leung, I own properties and I am involved in taxation of advisory work. Mr. Alan Leung, I have properties. Mr. Ronnie Tong, I repeat my previous declarations. Mr. Dong Li Jie, I repeat my previous declaration. Mr. Yu Xiwing, I repeat my previous declarations. I asked the administration to quickly take us through the response paper they gave us. In response to issues and questions asked on the last occasion, we issue a paper, CB bracket 1291/13-14 bracket 02. This is to explain issues relating to guardians and trustees. Under the law, the meanings of trustee and guardians are taken as ordinary meanings. There is no new meanings given to them in the provisions. Trustee is one who stands in a fiduciary or confidential relations to another, especially one who, having legal title to property, holds it in trust for the benefit of another and owes a fiduciary duty to that beneficiary. Guardian is one who has the legal authority and duty to cater for another person or property, especially because of the other's infancy, incapacity, or disability. These are the meanings under Black's Law Dictionary. Under the bills, there are only two groups of people who can, through guardian or trustee, engage in a transaction on their behalf and are exempted from the BSD. They are a minor or mentally incapacitated person, and they are Hong Kong PRs. It's only in these cases that a trustee and a guardian can be involved and exempted from the BSD. As we explained on the last occasion, these two groups of people are Hong Kong permanent residents, Hong Kong PRs. So, under the spirit of this amendment bill, all Hong Kong PRs are entitled to the same exemption from the BSD, the buyer's stamp duty. We don't just take anyone as a guardian or trustee. When the IRD, the Inland Revenue Department, deals with the applications, the applicants will be asked to produce documentary evidence to substantiate the claim. These documentary evidence, of course, varies depending on the case. But what we have in mind are documents including birth certificate certifying the parental relationship, the guardianship order granted by a court or the guardianship board. So there is documentary proof, not anyone who claims to be a trustee or a guardian. On the last occasion, members wonder whether a Hong Kong PR is acting on his or her own behalf. We mentioned this on the last occasion. Members were concerned that when a declaration is made, the person may not be very clear that there are funds provided by some other person in the transaction. if there is such an instance when a third party is involved in the provision of funds, normally it will be provided by way of a gift, a loan, or entrustment. The buyer will be in full cognizance of the facts and circumstances surrounding the contribution and will be in the best position to determine the nature of such contribution and to state the situation in the declaration. Where there are uncertainties before the declaration is made, the buyer can ask from the contributor the true nature of the contribution. When the facts are clear, then the declaration is made. Under most circumstances, there won't be any problem. There is another question raised in the last meeting. When there is a joint acquisition of a residential property by a Hong Kong PR and a non-Hong Kong PR, the BSD to be paid is the full amount, not a percentage. When we go into the clause by clause, we will give you a full explanation, but we will give you an explanation now. This is an anti-tax avoidance provision. We put in this provision because we're concerned that some non-Hong Kong PR acquires a property with a view to owning the property all by himself. But because he wants to circumvent the BSD, he will purchase the property jointly with a Hong Kong PR. That's why we have this anti-tax avoidance provision. When a BSD is to be charged, the full amount of the property is to be taken into consideration, is to be calculated. There will be no apportionment. Another issue relating to the purchase of a replacement property. When a non-Hong Kong PR property owner is made to sell the property not of his or her own volition, say for example because for drainage works or the acquisition of the URA, BSD under such circumstance will be exempted. When the property owner, by that I mean a non-Hong Kong PR, because a Hong Kong PR is exempted anyway. When a non-Hong Kong PR property owner makes an application for an exemption of BSD for the purchase of a replacement property, he will have to produce evidence to the IRD to prove that the original residential property to be replaced is acquired, resumed or sold under the specified scenarios. For example, the URA acquired the property. The documentary evidence may include a provisional sale and purchase agreement signed with the URA. Because the IRD requires documentary evidence to prove that under specific circumstance the original property is sold and a replacement property is to be acquired, and it's under this circumstance that the BSD may be exempted. I think the administration got the name wrong. It's URA, not the Municipal Council. Members also inquire about the resumption of underground strata in a railway project. The underground strata may be resumed, but such resumption should not affect the ownership of the property at grade. So there is no case for the affected owner to acquire a replacement flat. And the owner affected don't really need to acquire a replacement under strata. That is very unlikely. So when it comes to resumption of underground strata or the right to underground strata, there is no need to have a specific provision catering for that. Mr. Wong Ting Kwong, 5 minutes. Paragraph 9 of the document, replacement property. Does it only refer to residential property? What about a commercial property, a shop? The URA acquires the shop, is it the case that non-residential property will be dealt with the same way? Under this bill, BSD applies only to residential property. A replacement property refers only to a residential property. So there are other provisions targeting non-residential. That is the stamp duty A Bill 2013. That is the double stamp duty. Mr. James Toll, paragraph 4 of the document. The trustee may not have any relations with the Hong Kong PR minor as long as valid and law-binding entrustment can be produced. Is that right? The legally binding trust instrument. Well, the Hong Kong PR minor cannot produce a trust instrument showing that, say, for example, a non-Hong Kong PR uncle will act on his behalf. So your understanding of a valid and legally binding trust instrument, does it include the non-Hong Kong PR adult produce a declaration of trust? This person can purchase a property as a trustee for the Hong Kong PR minor. Is that right? Does that suffice? Well, let me ask this question first. Is that enough? It doesn't necessarily need trust instrument from the Hong Kong PR minor or the parents of the Hong Kong PR minor, because some people may like to be the trustee of a minor. There are many complicated scenarios, as I've mentioned previously. That is all right legally. That is legal. Deputy Secretary, when we draft this provision, in theory, guardian will suffice, but we put in trustee because we would like to cater for as many scenarios as possible. We can't rule out the possibilities that for a certain household they may acquire a property on behalf of the minor as trustee. That's why we have adopted a flexible approach for a wider coverage to cater for different scenarios to help Hong Kong PR minor or mentally incapacitated person. We would like to cater for different circumstances.
For some non-Hong Kong PR, if they just make their own claim and nobody would know that, well, when the IRD handles this kind of cases, they would ask the claimants to provide the relevant evidence. So we must have reason to believe that, well, the parents or the original guardians will take care of the minor's interest. So if the IRD has queries, he would ask the claimant to provide evidence to prove that the trust instrument is a valid and legally binding document. So there would not be this kind of scenario that is a stranger would suddenly come up saying that he's helping this Hong Kong PR minor to make certain applications, etc. So the IRD will be a gatekeeper. So legally, that person is trustee. The minor may not know him. There are such cases because it's written in the law. So how can the IRD be a gatekeeper? I think members have raised a lot of queries and concerns. They have also cited a lot of examples concerning the existing arrangements concerning minors and their trustees. There may be loopholes. So how will you handle this issue? Madam Chair, I'm not talking about guardians, I'm talking about trustees only. So, yes, how can you plug the loopholes in this regard? Now, maybe I can answer first, and then my colleagues can supplement. Just now I mentioned that the IRD would not handle these so-called trust instruments lightly. If they have suspicions, they would ask the claimant to produce more evidence to prove the relationship. Well, there is no need for a relationship in the law. A trustee is a person who's taking care of the interests of a minor. So what's the relationship? He's just a trustee of the minor. Other than the law, they don't have to have relationship. So I want to ask you that under the law, other than this legal relationship, they do not have any other relationship. Even though the parents do not agree, they still have this trust relationship. And how about the representative of the Department of Justice? Has he given you any advice? Well, you cannot just push all this onto the IRD. The IRD has to abide by the law. Well, we have talked about this for many times, Deputy Secretary. Now, when certain applications are made, then the stamp duty director would have to be satisfied with the evidence. I'm not saying that the trustee must have a blood relationship with the minor. However, as Mr. James Toll said, well, maybe this is a total stranger, and he claims that he's the trustee of the minor, and maybe even the parents do not know about that. So if you make a claim like that, the claimant has the responsibility to adduce evidence. Now, why are you suddenly claiming that you have a trustee relationship with this minor? So if the IRD harbors suspicion, then it will ask for further evidence. But in the law, how can you guard against this? Are there rules? Are there laws guarding against this? Well, you're just saying that the IRD would not handle this lightly. How about the IRD? Do you want to answer this question? So if you receive this kind of application and this trustee has no blood relationship with the minor, so how are you going to turn down the application? So you will not handle this lightly. But they have a trust instrument proving the relationship between the trustee and the minor, so you cannot reject the application. So you have to accept it in a painful and suspicious manner. Do you want to supplement? Maybe let us listen to other members' questions first, because, well, for this issue, we have discussed it many times. Ms. Chung, I have two questions first. About the trustee or the guardian, must they be Hong Kong PR or Hong Kong companies? Because for a trustee, it can also be a company. So must it be a Hong Kong company? And second, for the guardian or trustee, now if they acquire a property on behalf of the minor, do they have the authority to sell the property? And after selling the property, they get some proceeds. Would the government monitor the situation? Would the government make sure that when the minor achieves the age of 18, the proceeds will be given to the minor? Or the guardian or the trustee would still have the authority to make use of that sum of money? Now, if that person is a guardian, so for a minor, the most natural guardian, of course, is his parents. And if now, for example, under the minor guardianship ordinance, if there is a court ruling, then the court may rule that a certain person is the minor's guardian, or the court thinks that his parents cannot continue to be his guardians, and other people will be appointed as the minor's guardians. So there are rules. So if a person has become a guardian, he has to take care of all the interests of the minor. So after this guardian has sold the flat, the government would not monitor whether the proceeds will be given to the minor, because the minor is actually the de facto owner of the residential property. And we have never said that the guardian must be a Hong Kong PR. So a guardian cannot be just any person. That guardian must be able to take care of the minor, no matter whether it's pecuniary interest or the minor's actual living. Well, some members may think that the guardians and trustees may make use of the minor and they will speculate on the property. But if they do so, or if they sell their property in a short time, then they are bound by the special stamp duty. So it's not that there's a lack of monitoring. Mr. Ronnie Tong, I don't really understand how come we have been discussing this issue for such a long time, right? So we have to resolve this today. I don't understand what the government is thinking. My first question is, why do minors have to buy properties? If it's a Hong Kong PR's child, his father can buy a property, his mother can buy a property, his relatives can buy properties. They are not subject to restrictions. They just have to sign a trust instrument, and then they can give the ownership of the property to the minor. For a minor, if one of his parents is not a Hong Kong PR, it's still okay because the other parents can acquire a Hong Kong property. So the only problem lies with minors of which both parents are not Hong Kong PR. So you want to safeguard the rights of the minor. You want to give that minor the same rights as other Hong Kong PR minors. So that's why you have such a design. Now, if the minor is not exempted from SSD, you may not be able to attract these people to buy properties in Hong Kong. Now you are actually dividing the buyers into two categories. According to the basic law or ICCPR, some people may go seek judicial review because a bunch of people is exempted and another bunch is not. So if you are not giving exemptions to minors, then I don't think there's a huge conflict with the existing mechanism. But if you give a minor the right to own property and then you give him an exemption, then there will be a lot of problems, and I do not see an answer to these problems. Now you are saying that the owner or the guardian does not have to be a Hong Kong PR, and this is the biggest loophole. And this may destroy your whole bill. This is the biggest loophole. And you cannot come up with solutions. At the last meetings, Mr. Alan Leung suggested a solution. That is, you draw a line at the age of 21. But this is not exactly a solution. It's just that minors should not enjoy an exemption. I think this is a huge loophole. How are you going to plug it? How are you going to prove that? Now, if the guardian is not a Hong Kong PR and he used the name of a Hong Kong PR minor to acquire a Hong Kong property, how come that is not a loophole? Deputy Secretary, well, for this kind of discussions, we have had it for many times. Well, members have asked to draw a line at the age of 21, at the age of 18. For minors under that age, you should not accord them with priority. And we have asked you to go back and think about it. But after deliberation, you come back with an answer that cannot plug the loophole. Well, Madam Chair, Mr. Ronnie Tong has asked several questions, and I would like to answer them first. Now, first of all, for the owner of the property is the minor, not the guardian. The guardian is only acting on his behalf. I would like to clarify this point first. The question is, how many minors are like that? How many minors want to buy a property? Oh, for Hong Kong people, when they grow up and they get married, after they have children, they can't even afford to buy a flat. So how come you are creating such a loophole for such a small batch of people? Yes, there are not many people like this. According to the IRD's record, if properties are bought for minors in the form of a trust from January 2010 up to now, we have only seen 3 cases. So if you're saying this is a huge loophole, the hole is not that huge. Well, please let the Deputy Secretary answer the question first. Mr. Ronnie Tong, please be quiet. Well, Deputy Secretary, you have heard members' views that this is a possible loophole. In the future, people know that there is such an avenue, then this avenue will be turned into a loophole. So please continue. Well, previously, members have expressed their concerns. If we are going to narrow the scope, well, actually, I think members are very concerned about minors whose parents are not Hong Kong PR. So would they make use of their minors to acquire properties in Hong Kong? I would like to reiterate. Well, the spirit of this bill is that for all Hong Kong PR, they should be regarded equally. So if we are to categorize minors whose parents are not Hong Kong PR, or one of them is not a Hong Kong PR, etc., then that would be tantamount to discrimination. So can we have an across-the-board approach? That is, all minors should not be allowed to acquire property? Well, we have another perspective. Then for the minors whose parents are Hong Kong PR, originally, they did not have this problem, and now you are suddenly opposing such an obstacle. It's not that we are banning them from acquiring properties. They just have to pay some extra tax. I think we have discussed this numerous times before. We are talking about priority to buy property. Well, we do not have enough evidence proving that the non-Hong Kong PR residents would make use of their minors to acquire properties. So this may lead to another dispute. I think this is something we have to consider. Mr. Andrew Leung. Well, I think the government is trying to stir up a row. Well, many people are buying properties in the name of companies. This is not unlawful.
And now we touch on babies born to non-Hong Kong citizens and a mentally incapacitated person. Well, I think there is a problem of communication between the administration and the community, because we see a loophole whereas the administration did not. It's our duty to plug all loopholes. We want to plug all loopholes for you to make it watertight, but you don't share our view. There is a channel under which people can make use of babies born to non-Hong Kong residents to abuse it. Well, under the trustees law, under the trust law, when all the documentaries, when all the documents are in place, then everything is in order. Maybe the mother and father have signed the trust instrument as well. And this is a gaping hole. How can the IRD reject an application when someone comes to you with a proper documentation saying that this is a legally binding trust instrument? The law says this way, and the IRD says otherwise. How can it be? Maybe you should just use an administrative measure instead of the law to do it. Or you can't say that the IRD is supreme. The IRD says Wong Ting Kwong can do it and Jeffrey Lam can't. No, you can't do it this way. DS, please think carefully before you answer us. Who is to take this question? Is it the IRD? Under which provision can you reject such an application when a trust instrument is produced? Perhaps I would defer to the IRD about the way they handle such cases. Thank you. It's not for the IRD to invalidate a legally binding trust instrument. It's a matter of whether the document reflects the truth. Under the bill, it says that there should be documentary evidence to satisfy the Director for Stamp Duty. It's not the case that when the instrument is in order, we have to accept it. The person who claims to be the trustee may not have trustee concept in mind. So when we deal with cases, it's not the case that we will accept it when there is a proper instrument. If the trustee is not related to the beneficiary at all, then we have to look further. Whether the case will be approved depends on what other documentation can be produced by the claimant. What if the parents have given an explanation? Well, I don't know. I don't want everything to resort to the court. I know that the CE has said that. But you have to solve problems and plug loopholes for the public. You can't just say, well, see you in court. If that is the case, we don't have to do anything. There is no need to make applications to you because in the end you will ask people to see you in court. The drafting of the bill is poor. The concept is poorly drafted. Well, in reply to our queries about companies, you've said a lot of things, and now the same can't apply to this case. I asked the admin to go back to think about it. It's not just one single party. All parties think that there is a problem. Who is to take this question? So when there are problems, so you will rely on the Director for Stamp Duty to reject the case. It's very difficult for us to tell you how the Director will deal with it. But the law says that it is has to be to the satisfaction of the Director. We don't know if we introduce an across-the-board approach, whether it will give rise to other contentious issues. And we have to carefully consider it. Mr. Abraham Sheck. I hope that we don't have to talk about this any further, because I don't think the admin will give us justification to convince us. Why don't they simply tell us that this is our way, take it or leave it? Just tell members that I have enough votes and you have to support me. The IRD have spoken, but you are not a jury. You have to act on the basis, or you have to act with a legal basis. You can't say that if it is a minor error, then it's not an error. An error is an error, a loophole is a loophole. Just say, I can't explain it away, and this is the way. Then there is no need to spend more time on this. Some people accuse us of filibustering. It's not us. Look at the quality of the answers. We simply can't accept that. It's an insult to legislators. Whoever supports this bill will have to take responsibility. This is a poor bill. Hong Kong is dying. Yes. We never said that we have enough votes. We have had a lot of meetings and we do our best to explain to you, and we carefully consider the issues raised. Say, for example, redevelopment. And under certain circumstances, if by resolving one issue it gives rise to another, we have the duty to explain it. And we have heard members' concern. But when we try to deal with the issues, we have to tell members our concern and what safeguards are there in existing provisions. We communicate with legislators. We just want to do better. It's not that we don't listen to you. We've been listening to you. You listened, but you did not hear. Babies born to non-Hong Kong citizens should not be subject to a different set of rules. The Bureau Secretary has done it right, but how come when it comes to Hong Kong PR, they've been paying tax? It's just that this time, for various reasons, they want to buy a property in the name of a company. You discriminate against me. You charge me 15%. You can't even explain your principle. I've given you a lot of information. We should not get bogged down on this. Just put it to a vote and see if members will support it. Those who support it should take responsibility. I'm not talking about companies. I'm talking about Hong Kong PR. Just like the barrister said. This goes against the spirit of our law, the Basic Law, Article 25. Hong Kong citizens are equal before the law. We have a principle to abide by. We exempt Hong Kong PR because we recognize their housing need. No matter how volatile the property market is, there are always people who are buying properties for their own use. That's why we exempt an individual, not a company. And if we use an individual as an entity, then Hong Kong PR, whether it's minor or adult, should not be discriminated against. So our principle is clear. Article 105. Individuals and companies are equal. I declare. And this is the same as my previous declarations. Mr. Kenneth Leung. I have seen 3 points and I'd like to share with you. If we are to plug the loophole of people using trustee to buy properties, then if it's a transaction involving a trustee, then no exemption will be given. And some members mentioned about an across-the-board approach. Draw the line at 21 years old. If you're under 21, then there won't be any exemptions. And, well, in relation to the amendments, will we talk about that now? I give the legal basis. It's not discrimination against babies born to non-Hong Kong citizens, whether it is babies born to non-Hong Kong citizens or those are born to one parent who is Hong Kong permanent citizens. This is not fair. There are similar provisions in overseas jurisdictions. So in relation to this bill, what is the policy intent? You say that, well, if you have a Hong Kong permanent ID or those who are eligible for a Hong Kong PR ID, then there is exemption. Is it so simple? I think the more it's explained, the more vague it is. The policy intent is very straightforward. We want to cool down the property market so that it will go back to normal. We understand that there are housing needs of Hong Kong PR. That's why we need to give them exemptions. Well, will we just deny exemptions to all trustees? And we will further consider that. But if we deny minors of any exemptions, then this will be unproportionate, and it may cause other controversy. Next, Miss Chen Yun Han. You always use unproportionate measures. I did not want to ask questions, but in the end I decide to. I support the cooling measures. But you said that there are only 3 cases, but there will be babies born to non-Hong Kong citizens. There won't be 3 cases because as long as there is profit to be made, they will come to Hong Kong to do so. There are diverse views. I don't agree because it involves issues of the 2 places. We have to be very careful. Deputy Commissioner of the IRD. He said a lot, but it's just hot air. We're talking about Hong Kong PR. They live with their relatives, grandparents. Say, for example, they live in Shanghai and they need a lot of things. We have to be very careful. We have to keep an open mind. Perhaps we need to apply this idiom, lesser of the 2 evils. We choose the lesser of the 2 evils. We do this, we do that, and in the end we do it this way. Well, when you oppose to it, you oppose. When you support it, you support it.
I don't need an answer. Well, the government has to be clear about this itself. Well, you can see that people are ready to make use of this loophole, and I would like to warn the government. If you do this, then you will be encouraging people to come to Hong Kong to give birth to babies. This is true. They will try their best to do this because they can make money by purchasing properties. Mr. Lam, I would like to declare what I have declared before. I support the government. I totally support the government. I think the government should be given a chance to do the best. But after listening to members, there are still issues that we should address. But the Deputy Secretary has also said this before, that is, they do not have enough manpower to do all the vetting and process all the applications. Just now, the Deputy Commissioner of Inland Revenue, Mr. Tam, said, so when there is an application, they will look at it, but I don't know how much manpower will be involved. Members asked a lot of questions, and they also put forward possible scenarios, and it is possible that you may have to deploy a lot of manpower to handle numerous cases. So in the future, will you be coming to us to apply for more manpower or for more resources? And we cannot be biased. As Ms. Chen Yan-han said just now, she is also very concerned about the mainlanders. Minors whose parents are non-Hong Kong PRs and minors whose parents are Hong Kong PRs, there may be conflicts in the future, and we do not want to see this. So we really have to handle this issue carefully. As for companies, you also mentioned that, yes, that may give rise to a loophole. So that's why you plug it, and there will be no more loophole. Just now, Mr. Andrew Leung also said that now there's no evidence proving that there is a loophole. Many people have acquired properties in the name of their companies in the past, and there was no problem. So this time around, for the minors problem, we have asked a lot of questions, but still we do not see a perfect solution. So when you vet the applications and when you look at the manpower deployment, how can you make sure that there is absolutely no loophole and there will be no litigation? Mr. Ronnie Tong is a very hardworking. Every time he would try to find out whether there are any possible business opportunities. But we do not want to see a lot of litigation. Litigations will lead to division in society. So I hope that in terms of procedures and law, things can be handled in a comprehensive manner. There's no loophole regarding minors whose parents are non-Hong Kong PRs and regarding other issues as well. And also, when we raise questions, you have to think, and if you cannot come up with an answer immediately, then these questions will accumulate and it will become a bigger and bigger problem. So how are you going to deal with all these, Deputy Secretary? Madam Chair, just now our IRD colleague said that, well, he cannot just imagine all sorts of scenarios, but when there are applications, he will handle the applications, and they would not just trust a simple documents. They will be diligently vetting all the documents. Yes, we've heard Mr. Lam's view. It seems that now you have such an impression. That is, for minor whose parents are non-Hong Kong PRs, they will definitely be used, and they do not have a need to have a flat. But minors are Hong Kong PRs as well. So if we are exempting Hong Kong PRs, then these minors have to be exempted as well. So members also suggest that we should ban all minors from acquiring properties, and that's simpler. But would this lead to other disputes? We cannot handle this lightly. For minors whose parents are non-Hong Kong PRs, we would not comment that whether they need a home to live in. They may have the need to buy a property. So would they be used by people to buy property? And if they are used in this way, and if the people who use them want to make profits by speculation, these people are also subject to SSD. So it's not that they are not subject to any of the measures in a basket. Well, we cannot say that there is no case now, so we just do not have to handle it. Now, for the competition ordinance, we also discussed a lot of issues like this. We have raised a number of scenarios, and then you would have to provide answers to this scenario. So now we have asked so many questions. Can you talk to ILD? You have to try to find out what possible scenarios there will be and give us answers. Is that possible? We do not have precedents, so it's different from the competition ordinance because we do not have precedents. So the ILD would just look at the law, and then they have been adopting a very prudent attitude, and they will continue to do so. Who is going to ask the first round questions, Mr. Yu? Well, we have talked about this for a very long time, and we have discussed all the loopholes. So I hope that we can really wrap this up at today's meeting. Deputy Secretary, if you think this is your final answer, then you have to tell members. Or will you just go back and think about it again? Because there are still a lot of problems. I'm not just talking about the minors whose parents are not Hong Kong PRs. There are also other possible loopholes, and Hong Kong minors may also be used as a tool for investment. So if there are two trustees and the parents agree, then the two trustees may use the minor to buy properties. And if you say that if it's a short-term speculation, then they will have to pay SSD. But if it's not short-term speculation, then the trustees are allowed to make use of the minors to evade BSD. Have you thought about that? Now, if we continue to come up with all sorts of scenarios, then there are numerous. It's just not just a minor. Any person can be utilized by another person. So we cannot expand this indefinitely. We can just say that this is the principle. So when we look at each application, the claimant would have the responsibility to provide evidence so as to convince the collector of stamp duty. Now, you can say that everybody may be used by other people. Both Chairlady, yourself, and I can be used by other people. So we should stick to this principle. And when we vet each application, we would have to do it prudently. So I think we will just do it this way. I don't agree with you on this point. Mr. Yu Swing. Thank you, Madam Chair. The administration has been very prudent in dealing with companies. But when it comes to trustees, the administration has put forward a lot of excuses. Well, the biggest problem is that we are talking about a minor, and if his parents are non-Hong Kong PRs, so how would they look at this? Well, for the definition of a trustee, we have been struggling with it for a long time, and still there are many loopholes. So for these non-Hong Kong PRs, they may not know Hong Kong laws too well. They may think that this is a channel for them to make money. So they would entrust a trustee to do this. Then the government would have to spend a lot of resources to tackle different scenarios and even on litigations. So originally, we just want to curb the rise of property price, but now we have to spend a lot of resources tackling other issues, and this is totally unnecessary. Well, there is no problem with the minor, but it's the group of people that's behind him, those with vested interests, as non-PR, Hong Kong PR residents, parents, etc. So you can say that we are doing all this for the interest of minors. So up to now, we have only seen 3 cases like this. So it proves that there is not such a huge need. So maybe we should really apply the across-the-board approach. That is draw a line at the age of 18 or 21. Well, the administration is trying to explain, but I do not find those explanations meaningful. Yes, we have talked about this for a long time. That is draw a line at 18 or 21. Then those above that age will be given a priority in purchasing properties. DFJ, do you want to respond? I think this is the simplest way of addressing members' concern. Well, I have replied to members already. We have thought about this. But would this lead to another dispute? No, because in the original bill, even though you are a minor, and we don't care whether your parents are Hong Kong PR, we would give you the same rights. Because all Hong Kong PRs, if they buy a residential property for themselves, then they will be given the priority. But if we adopt an across-the-board approach, that is, all minors cannot enjoy this exemption, then for those who originally had this entitlement, would they think this is unfair to them? Because we are talking about people and company, and these are totally different parties. We have already considered this option, but we are worried that it will lead to another dispute. But you cannot ease our present dispute. If you do not want to give rise to another dispute, but the present dispute has not been settled yet. Mr. Wu Chiwai, I find it very strange. Well, remember we were talking about companies and we thought that was a loophole, so that's why we had to adopt an across-the-board approach. Now we are talking about trustees. Trustees can buy properties for minors. And you are worried that this may lead to disputes and litigations. So for a Hong Kong person's company, that may also lead to litigation. So let us clarify our principles first. What is the principle? That is to accord priority to Hong Kong people when it comes to purchasing property. So that's why we have BSD. Now, okay, Hong Kong companies, that may be a loophole and you have to plug it. So now we're talking about trustee minor arrangements, and this is a loophole. So why don't we have to plug it?
Housing needs. That is my second point. Under the laws of Hong Kong, those under the age of 18, if they apply for PRH units, they will have to do so with their parents. Arrangements for minors, usually they will be part of they will be part of an application of their parents. How come when it comes to property purchase, they are separated? How big can the loophole be? And I'd like to hear from the IRD. You talk about 3 cases. And you also talk about the documents to satisfy the IRD. What documents were produced in those 3 cases to satisfy you? Of course, back at that time there was no BSD, so it may not be very much related. But I'd like to know how it operates. What documents can satisfy you? DS or the IRD? I will first answer, and then I will defer to the IRD for them to explain about the operations. It's difficult for us to jump to the conclusion that there is no housing need for babies born to non-Hong Kong citizens. They may not be in Hong Kong yet, but for some, they may come to Hong Kong to go to school. Maybe they would like to have a property in Hong Kong and for them to live here, to be taken care of by their relatives. And that is only one example. So we can't say for sure that there is no housing need for these children born to non-Hong Kong permanent citizens. because of the special circumstance, they don't live with their parents, or their parents may come to Hong Kong later. We just want to cater for the needs of this group of people who are also Hong Kong PRs. But the stamp duty is a demand-side management measure, which means that through the BSD, exuberant speculative activities will be curbed. You said that Hong Kong PR companies cannot be exempted because it may be abused. But for this, if a property can be purchased on behalf of a minor through a trustee, then it is exempted. It's a loophole. How can you just not deal with this loophole? Can the IRD reply to Mr. Wu's question? The three cases. On the instrument submitted, it stated clearly that the purchaser is purchasing a property on behalf of the children. But since it doesn't involve exemption, so we don't have to investigate into whether whether a trust is involved. The IRD is not the judge. It's not the case that if we don't believe you, that's it, or we'll ask you to see you in court. When the provision contains the word trustee, we will have to interpret it. We have to obtain information in processing the application. That is in relation to the case. It's not just about the document. That is a trust instrument. That is an accept. That is he or she is a trustee, and we will take it at face value. We will consider the explanation given and seek further information based on that. Mr. Lam Tai Fai. Members have given a lot of comments, and most of it opposite to the view of the administration. If we have further consultation, you will find more diverse views. The DS talks about the rights of children born to non-Hong Kong citizens. They are also Hong Kong PRs, and we should not ignore their housing needs. Well, if they come to Hong Kong to study and then they will buy a property, that is possible. But how can you track their case to make sure that the property is occupied by the child? Well, what if the parents buy a property in Sheko when the child is going to school in the North District? Will you reject their case because the child is going to school in the North District? They can't possibly live in Sheko, but maybe they prefer to travel. How can you regulate it? The parent, the guardian, or the trustee can say that the property is purchased for the use of the child. But that may not be the case in reality. It may be for lease, it may be for sale, for them to make a profit. I'm sure that if you ask more, there will be more different examples given to you. But this is a loophole. Why not plug it? I don't know whether this is a loophole. For a Hong Kong PR, exemptions will be given because the property is purchased for their housing need. We don't require the property to be close to your work. So there is no reason for us to require the property bought for the child to be close to the school. We recognize the housing need of Hong Kong PR. It is in relation to all Hong Kong PR. We will not monitor their cases to find out where they bought it. So it doesn't really matter whether the property is for self-occupation. It can be bought only to be rent to others to make a profit. Stamp duty is safe. They can charge a lower rent. And then, if that is the case, then this measure has failed, unless no exemption is given. Otherwise, please let the DS answer. There is no reason for us to put in different restrictions because of the status of the person. If you see it as a huge loophole, well, as I said at the beginning, it will be the most simple way to not give any exemption. But in order to cater for the housing need of Hong Kong PR, we have to grant exemption. These are for, say, redevelopment or self-occupied residential properties purchased by Hong Kong PR. If we have further restrictions on the same group of people, that is against our policy intent. Well, what if I identified a case of abuse and I report it to you? Will you see it as a loophole and deal with it? We don't see it as a loophole. We don't monitor the location of the property purchased by the Hong Kong PR. So we don't think this is a loophole. Or then you are tying yourself down. 3 members would like to speak in the second round. We've had discussions about the same topic. The views of members are very clear. DS, your explanations fail to convince members, and they fail to allay the worries of members. You said you want to avoid another round of argument, but you have failed to convince members. You will have to go back to think further. 2 minutes for each member in the second round, and then we will proceed to what we're supposed to do. James Ho. It's not just about trust. I have other issues to address as well. Well, I will first talk about trust, because I have further questions about this response document. Paragraphs 2 and 3. The IRD said that out of the 3 cases, at the time of the purchase is a trust, so it's all right. Then it's exactly what I said in my first round. I said that the time it was purchased is stated as trust. There is no need for the trustee to be related to the beneficiary. It can be a gift. Well, if it's type 1 baby, say for example, baby's born to a parent who is a permanent citizen. But the issue may be complicated. Maybe one parent is a Hong Kong PR. That parent does not want to purchase a property for the partner. And the property is purchased on behalf of the child, because the Hong Kong PR does not trust his or her non-Hong Kong PR partner, so a trust is used to purchase a property for the child. The IRD said that they are aware of the loophole and they would rather take the risk instead of being subject to judicial review. Of course, there are other issues, say for example, why is it allowed for Hong Kong for minors? Paragraph 6, anti-tax avoidance provision. Have you carefully thought about whether an exemption should be given? Will you be able to stand when you challenge legally? Is it fair? When it comes to trust, I will defer to the IRD. Mr. James Toh mentioned about anti-tax avoidance. And if this is the reason to not give tax exemption to minor, well, I will seek further views. But my initial response is that if there is no evidence or cases to support this, it's difficult for me to say that minors will be used and an adult will not be used by others. If we simply rely on anti-tax avoidance, then I am concerned whether it's justified to put in such a provision. I now defer to the IRD. Mr. Tan? My understanding of Mr. Wu's question was that in relation to the 3 cases, a parent may declare that it's a property purchase on behalf of their child, and how we investigate to find out whether it is a genuine trust. In those cases, there is no need for us to know whether it's a genuine trust. Perhaps parents bought the property for their child or for themselves. Because since it's not subject to BSD, we don't have to investigate into it. I was just saying that when they say that they're doing so on behalf of others, we have to accept it on face value. Mr. Ronnie Tong, I don't know how much the administration knows about trust arrangements. When a child is involved, a common practice is that a property is purchased by the parents, and it's only when they reach 18 or 21 can they take over the interest of the property. Before that, the right to lease and the right to accept income, rental income, it goes to the trustee. And another type of common trust in a family is in relation to a group of minor beneficiaries. Some of them are Hong Kong PR, some not. And in this case, will there be exemption? And the third scenario, first, if the beneficiary is Hong Kong PR and the trustee is not, the trustee may be a company. Will there be exemption? 2. The beneficiary is not a Hong Kong PR, but the trustee is. Will there be exemption? 3. The trust instrument involves a number of people. The beneficiary is a group of Hong Kong PR and non-Hong Kong PR, and the trustee is a group of people with Hong Kong PR and non-Hong Kong PR. And there may be more than 5. I see many different forms of trust. So these 5 first. Can you tell me one by one whether an exemption will be given and why?
I think there is only one basis. That is, the beneficiary would have to be a Hong Kong PR. As for Mr. Tong's questions, Now, if the minor, the beneficiary, is a non-Hong Kong PR, then there's no exemption. So the basis is that the minor himself must be a Hong Kong PR. And it is because he's a minor, then he cannot sign certain legal documents. So that's why his guardian or trustee would have to do such things on behalf of him. So if that person is not a Hong Kong PR, then all those scenarios will not appear. Sorry, this is not a satisfactory answer. For the first example, yes, the beneficiary is a Hong Kong PR, he's a minor. Now, before he becomes an adult, he is not the beneficiary. For example, the rent collected is not given to him. It will be given to the parents, that is a non-Hong Kong PRs. Then what would happen? So is this the kind of trust you are talking about? And also for other trust arrangements, a power will be given to the trustee. I do not know how to translate power into Chinese. It may be a power to implement, and the beneficiaries may be a group of people. So for this group of people, they cannot enjoy exemption because maybe a few of them are not Hong Kong PRs. And who's going to enjoy the benefits during this period? Now, if the beneficiary is a Hong Kong PR minor, but if the people who are enjoying the benefits are not Hong Kong PRs, that means people who are non-Hong Kong PRs, then they can collect the rents, they can enjoy the benefits derived from the property. Madam Chair, for Mr. Tong's question about the trust arrangement, I think I have to go back and seek the views of the DOJ. That's exactly why I say you do not know anything about this. Well, this is very complicated. If you know about it, then you won't think it's complicated. Yes, I'm not a lawyer. Well, let the government official reply first. Now, for the basis I mentioned just now, we would hold on to it. It's for a group of people. Well, actually, for this whole trust arrangement, we will look at that particular person. If that person is a Hong Kong PR minor, then he can enjoy such an exemption. So for the trust arrangement, it is for that particular person. It's not about a trust for a group of people. We are just looking at that beneficiary, and that beneficiary is a Hong Kong PR minor. As for beneficial ownership, is enjoyed by the Hong Kong PR minor. As for the rents, well, I cannot answer this question right away. I have to go back and seek views. Now, maybe the government has not thought about all these details. I just cited 5 examples. Please give me a written reply. The Deputy Secretary gave us an answer. And it's about a policy. So how are you going to implement this policy under the law? I think you have to draft the bill more detailedly. So for the trust arrangement, you must give it a more clearer definition. Mr. Wong Ting Kwong, I would like to declare what I have declared before. For this bill, I think actually members are thinking for the government. They are trying to plug loopholes for the government. When we vet bills, we have to be forward-looking. Otherwise, if we enact a law, it may give rise to other problems. Well, the ILD told us that there has been no precedent. Indeed, this is a new law, so there is no precedent. But we have to consider the possibility of loopholes. So for this trust problem, let us not just look at minors whose parents are Hong Kong PRs or non-Hong Kong PRs. Actually, each child, and including those mentally incapacitated persons, the people behind them are actually the beneficiaries. Well, if a person is greedy, no matter whether he's a parent or a guardian, he can make use of a minor or a mentally incapacitated person to achieve his own goals. So can we just open this floodgate? The government must think carefully about this. Now, we have these 2 cooling measures, and they are not permanent. At an appropriate time, they will be abolished. So we are just buying time with these 2 cooling measures. In the future, when the demand and supply balance, these measures will no longer exist. So some greedy people would make use of this period to speculate. So the government must think carefully. This loophole must be plugged. As I said just now, for minors and mentally incapacitated persons, if they have guardians or parents, then they would be allowed to act on behalf of the minors. Other than these people, nobody would be allowed to do that. We should try our best to narrow the loophole. As a guardian, a formal guardian is not just anyone who claims to be a guardian. Then if he even though he gets the benefits, we would think that's reasonable, and the law would allow him to do so. Thank you, Madam Chair. Deputy Secretary, have you considered this point, or will you go back and think about it? Yes, we will think about it. Ms. Chung, I just need 1 minute. I am a bit worried because there are many loopholes. If a person does this, how can we sue him? Well, it seems that there's no way that you can definitely win the case. You say that there have only been 3 cases. Well, but you may remember that there were only a few dozen mainland pregnant women coming to Hong Kong to give birth to babies, but then the problem grew rapidly. Well, you may consider the housing needs of these minors, but you can actually rent a flat. The acquisition of residential property is an act of investment. And I would like to remind you, in Hong Kong, there are many laws restricting people under the age of 18. For example, under the age of 18, you cannot vote, and you cannot go into a bar. And under 16, you cannot stay home alone. So why do you want to buy a property if you cannot stay home alone? Well, for these, Mr. Kenneth Leung, well, for this loophole, if you want to plug it quickly, have you considered this? If this is a trust, then you should require the trustee to be a Hong Kong PR. Then you would give him an exemption. So you just need to amend the definition of trustee. Then you can pose a deterrent effect. Now, because if the trustee is a Hong Kong PR, then you would ask him for a lot of documents. Now, if the trustee is living in Gambia, Africa, then what can be done? So please think about this. Mr. James Toh. Madam Chair, the government does not want to be unfair to a group of people because that's a constitutional challenge. And Mr. Kenneth Leung's suggestion is a possible solution. Now, you are doing this because this is an anti-tax avoidance provision. Now, if there are millions of Hong Kong PRs, they can be trustees. And if you say that this is unfair because the minor cannot buy a property alone and he needs a trustee, and this trustee must be among the millions of Hong Kong PRs, definitely you can find one. You cannot say that because this trustee must be a Hong Kong PR, then you are denying the minor of his right. This is feasible. I hope the government can think about this. In other words, just now many members also mentioned this. Now, under this scheme, I'm not talking about the possibly revised scheme. So for a company, it can be the trustee of a minor or a mentally incapacitated persons. Yes, for today's draft, you are correct. But for trustees, it's only applicable to minors and mentally incapacitated persons. But if it's a company, the loophole will be bigger. Madam Chair, I would like to ask a question about paragraph 6. Mr. To, are you asking about other issues? Because Mr. Chair would like to ask questions first. Mr. Paul Chair, well, I declare what I have declared before. For babies who are born to non-Hong Kong citizens, there was one big problem. That is, they enjoyed too many benefits. Well, because when a child is born in Hong Kong, he is entitled to a lot of Hong Kong welfares. And now the government wants to give them yet another exemption. So this is a catalyst for mainlanders to come to give birth to babies in Hong Kong. And for this benefit, there are a lot of loopholes. Mr. Kenneth Leung has just left. He mentioned Gambia, and this reminds me of something. Well, there are many mainlanders who come to invest in Hong Kong, and they actually have Gambian nationality because they have to be a foreigner to come to Hong Kong. So that's another loophole. Mr. Tong asked a lot of questions concerning trust arrangements. So how about the company issue? Because if you have to change the company law, then this will give rise to many other problems.
Under the common law, when it comes to trust, there are many different examples, much more than what Mr. Tong said and much more than what the DS knows. And if you open this can of worms, you will not be able to handle it. You may have to change the trust law. And these are not what you want to deal with. I don't know whether you know or not. Is it my first round? I'll be as quick as possible. When it comes to trust, there is presumption of trust. If a parent pays to buy a property, it's not. The assumption is that it will be a gift to the child, not purchased on his behalf. You say that, well, if you produce a birth certificate, that suffices. But during the interim period, all the income may go to the parent. The property may be sold, rented before the child reaches 18. And the quota for exemption for the child would have been used up. Is that another incentive you give for people to come to Hong Kong to give birth? Yes. Mr. Tse mentioned something he said previously, that there may be a possible loophole, and I'd like to reply to his first point, whether we give too many privilege too many preferential treatment to children born to non-Hong Kong citizens. However, we feel they are Hong Kong PRs. And that is the principle under which we give them an exemption. A quick word. It's not that I discriminate against children born to non-Hong Kong citizens. Mr. Kenneth Leung mentions about a guardian being a Hong Kong PR. That is discrimination, but I'm talking about possible risks and loophole. Maybe the exemption should be taken away. Your intentions might be good, but you're opening a can of worms. Can I reply? I thank Mr. Jie for raising this issue. Mr. Leung has left the room. We have considered whether to impose further restrictions that the trustee or the guardian have to be a Hong Kong PR. We have thought about it, but by doing so, we have separated minors into different groups, and it may be discriminatory. We thought about it and find that it is not a simple issue. Mr. Ibrahimchak. There should not be any discrimination. That is very important. But there are different goalposts, and they move the goalposts. Trust is the same as companies. If that is allowed, then you have to accept my amendment, and that will solve all the problems. Please consider my proposed amendment. My amendment will plug loopholes. Anything to add, DS? No. Mr. To is not here, so I will conclude. Well, we have been talking about this issue for a long time. In relation to the possible loophole, I'm sure the admin is very clear. Please reflect the views of members. I hope that next time you will come back with a final answer. If you think that you have weighed everything up and this will be the approach, just say so. Don't give us the many interpretations, because we're talking about a likely loophole. Anything to add? IRD? No? Well, Mr. To, you are asking for clarification. Perhaps you will wait for next time. Paragraph 6. You may begin. Hong Kong PR and non-Hong Kong PR making a joint acquisition. The example I cited last time, but it didn't really make sense because the non-Hong Kong PR holds, say, 50%. Well, in the previous stamp duty A bill, is it 2010? The one endorsed? Well, if the property is resold after a short time, the SSD paid will be charged according to the percentage. There is no differentiation between Hong Kong PR and non-Hong Kong PR. Well, paragraph 7 says that it is anti-tax avoidance. The DS answer to issues before paragraph 6. Are there any cases that warrants such unfair treatment because of anti-tax avoidance reasons. Say, for example, a non-Hong Kong PR can make use of Hong Kong PR to use the loopholes. Are there any previous cases? Or is it just a guess that you need this anti-tax avoidance? If the Hong Kong PR is an adult, then every Hong Kong PR may be used by others. Why do you say that if it is a joint acquisition, the Hong Kong PR may be used by another? Then your argument doesn't really stand. I will defer to the IRD for details. In short, when it comes to stamp duty, it is charged to an instrument. And the example of Mr. Toh, that it is based on 50%. I believe that in that case, well, the possibility of similar cases will be low. Mr. Tam, we found that in Singapore, there are similar provisions in their special stamp duty. There will be different treatments depending on the status of the buyers. But if someone buys a property with someone who is subject to a lower or nil special stamp duty, then a different rate may apply. If a non-Hong Kong PR purchases a property with a Hong Kong PR, intending to reduce the BSD, is not difficult to do. So there is a need to plug this loophole. Well, you will have to worry more if it is a minor, because they are not in a position to protect themselves. But if we're talking about two adults of lucid mind, they can protect their own right. They will not be used. It's impossible. So unless there is a solid reason, if you say that it happens in Singapore, well, there are a lot of draconian measures in Singapore. Can you tell me that there is some rational basis instead of telling me that there are cases in Singapore? If you have to find someone to do it just to reduce half of the tax, but then you are giving half of the property to that person. If you want to dump that person can claim ownership and take back the property, unless you have reason to believe that the other person did not take out a dime to pay the property. A Hong Kong PR may have a spouse who is not a Hong Kong PR. And under certain circumstances, they may not apply for PRH units. And when it comes to buying a property, it may be a very small and dilapidated property. Why can't they do it? What is your worry? Yes, let me try to explain. The two examples cited by Mr. Tom will not happen. Even if the wife is a non-Hong Kong PR, there is exemption. And we use the full consideration to charge the 15% when it comes to a joint acquisition because the IRD is concerned that the non-Hong Kong PR pays for the property, but in order to reduce the BSD to be paid, they will acquire the property under a joint acquisition with a Hong Kong PR, relative or not. But that means you're giving away half of the property. If it's a joint acquisition, it takes both signatories. There is protection because the property can only be sold when the two signatories sign. So from the perspective of the Hong Kong PR, from the non-Hong Kong PR, there is protection. But at the same time, they can they can pay a less amount of BSD. So there is temptation for the non-Hong Kong PR to do it this way. That's why we have this anti-tax avoidance provision. Whether you hold it for 30% and your friend, a Hong Kong PR, holds 70%. With this anti-tax avoidance provision, the full consideration is calculated when it comes to the charging of the BSD. So there is no way for the non-Hong Kong PR to avoid tax. Even if you charge by the percentage, there will be apportionment. There won't be any tax avoidance because it takes both signatories to sign to sell. You illustrated the case the other way round. They want to use this to reduce the tax to be paid. Well, we're talking about both adults, and both of them know that they share the property. Well, if the other person refuses to sign, you can't sell the property. And that's why they can't use it to avoid paying BSD. Well, this is to prevent two people to avoid tax payment using a joint acquisition. Non-Hong Kong PR who would like to use this way to avoid tax will do so and pay less BSD, and there is protection because it takes both signatories to sign before the property can be sold. Without the provision, there is incentive for the Hong Kong PR to do it this way to avoid paying tax. Are there any cases that there is only half of the entitlement and the full amount is charged?
Any examples? Well, other than Singapore? Other than Singapore, we do not have this kind of information in hand at the moment. Mr. Chair, well, please tell the administration what you want them to clarify as soon as possible. Well, I would like to supplement Mr. James To's question. Well, the Deputy Secretary said that if there's no exemption for apportionment and you are worried that somebody may avoid tax and this is a deterrent, then I am afraid that all the Inland Revenue laws would have to be amended because we are relying on people or companies to report to you in an honest manner. Now, if you want to dampen the incentive, then what Mr. James To said was one of the reasons. And also, You are worried that people may make use of this as a loophole. Actually, it's not always about signed documents. Well, Chinese people still honor oral agreements, and they may cheat you together. Well, if they are very good friends, and if they are not too educated or they do not know a lot about the laws, then they would rely on oral agreements. Oh, if you are saying that you only look at the apportionments in an agreement, then I think that's unreasonable. Because he only has 50%, then he has to pay the full rate. I think that may not be practicable. Or maybe you should abolish all the exemptions. Otherwise, this is really not a clear cut. And what you said is not too reasonable, and it seems that is a bit discretionary. Mr. James, though? Okay, Secretary. Just now, the member said that there may be some secret agreements. That is, it's not in writing. And because I'm a very good friend of yours, then we will just rely on oral agreements. Well, I cannot say that this would not exist. However, if it is a secret agreement, then for the non-Hong Kong PR who wants to avoid tax, he actually runs a risk, because in law, the property belongs to his good friend. So if anything happens between them, because the property is registered under his friend, then he would not have any right to the property. So he should assess his own risks. If they jointly acquire a property, then the risk is lower, and there's a chance of avoiding tax. We think this is very likely, so that's why we need this anti-tax avoidance provision. I do not know if you always buy or sell properties. What you said is just something imagined. That's not how the market operates. Otherwise, there would not be so many people buying expensive properties, including myself. Well, there are many incentives in the market. It's not something in writing. And for Hong Kong's system, it's not just about register. For trust arrangements, you can do a lot of things. And if you do not follow these rules, then you will be subject to litigation. So I hope you can try to find out more about the actual operation in the market. Mr. Abraham Sheck, I would like to follow up on Mr. James To's questions. You said that the wife can be exempted. Yes. Well, now people are cohabiting, and one partner may be a non-Hong Kong PR, and also there are same-sex cohabitations, and they are not married couples, of course. So how can you say that the 50 persons cannot be given to the Hong Kong PR? That's totally unreasonable. How can you explain these scenarios? Can you answer my questions concerning these two scenarios? Now, a couple, one of them is a Hong Kong PR, the other is not. They may be of the same sex or of different sexes. So how are you going to solve this problem? I think the government would not look at these elements. Now, if you look at paragraph 7, that's the case. We would not consider this, because the law is very clear. Now, if it's a joint acquisition and if BSD is to be exempted, now maybe, okay, take it as two persons. One is Hong Kong PR, the other is non-Hong Kong PR, so they must be close relatives, and there is a definition in the law. They must be parents, spouses, etc. You are talking about 50% exemption. But now you are taking away the Hong Kong PR, that Hong Kong PR's 50%. I don't think she can answer my question. Well, you let her continue first. The one who has to pay the BSD is the non-Hong Kong PR. If it's a joint acquisition and if the other person is not his close relative, then the BSD still has to be charged. Well, I'm at my wit's end. This government just won't listen to the people. For replacement property, I have two questions. Paragraph 8. You say that you want to take care of a non-Hong Kong PR. I didn't look at the details. If the URA, okay, it's a land resumption scenario. Maybe it's for railway or something. And the owner is a company. So the property will be resumed, right? So this company buys a replacement property. Under this scheme, is this allowed or not? Madam Chair, you know what I'm saying, right? That is, the owner is a company. Secretary? Can you answer this question, or you want Mr. Toh to ask the question again? Well, under the present bill, if the owner of the property is a company, then this company will be included. Yes, that's my worry. Well, this is to cater for the scenario of compulsory resumption, and you want to avoid unfairness. At the end of paragraph 9, you say that there's no limitation on size, price, and time of transaction. Now for Hong Kong PR, there's a half-year limitation. Now this is an involuntary act, and the land and the property is resumed. How come this is so lenient? Is it because it's a land resumption? I'm worried there will be such a scenario. I reminded you last time. I don't want that. Well, for redevelopment areas, small units are all bought up. Well, that is after a declaration of redevelopment, all these small units are bought. And then they would hold it until the end. Well, I'm a director of the URA, I would like to declare my interest. And URA would not buy it. Why? Well, because for the compulsory sale, I can use this as a vehicle, and then I can buy a property which was $10 million. And many people will buy this kind of units, and they can get a flat swap, and they can save tens of millions of dollars, and they would hold all these units until a compulsory sale. Then there would be a huge problem. Well, because for many of these units that you are going to resume, they are very small units. And if it's a company, then it's even worse. I'm not saying that you have ill intention, but can you impose reasonable limitations? Otherwise, you will just be creating troubles. Yes, we understand Mr. James Toh's view. Now, there's no limitation. It's not like in another ordinance. It's a flat swap because they can pre-plan. And here, well, that owner does not want to buy a replacement property, but maybe his property is forced to be sold, etc. So no matter what, we have to think about this. We want to help the property owner because he's doing this in public interest. Well, can I suggest something? Well, you can have an anti-tax avoidance provision, but there should not be a time limit, and you can double the size or even triple the size. Then the chance of being used is limited, because this is a property for replacement. So originally, the unit only was 3 million, and then you're buying a 100 million property. That's impossible. That's a reasonable limitation, right? Secretary, any supplement? Go back and think about it. You will just benefit people. So with regard to this paper, do you still have any other questions? Yes. Resumption of underground strata, paragraph 10. Yes, I understand. Well, in common sense, that is not a replacement property, but this is a legal issue that is in the law. For example, on 2nd Street and 3rd Street, the underground strata is resumed. Well, legally, if you resume a residential property, then I go buy another residential property. So when you look at it from the point of tax, is about residential property, so you have to pay tax. So my residential property is resumed. In definition, it's a residential property, and then I buy another residential property, and I want to claim this exemption. Well, because I was forced to sell my residential property. So in the law, can you tell me that? Well, for what has been resumed is not a residential property, or how can you ensure that the newly bought flat is not a residential property? Can you prove that it is a replacement underground strata? I'm talking about common sense. I'm not talking about dictionary meaning. Can the DOJ give us a more detailed explanation? Otherwise, for those who are the subjects of resumption of underground strata, they will be very happy, and they can buy many new residential properties.
We have to first clarify the legal issues. I don't accept your answer. DS. Paragraph 10. What we're trying to say is whether it involves the residential property. We will look at the definition of the bill. And you can't say that, well, since it's acquired, it's a residential property. And we're talking about a replacement property. It's to replace something. Well, the most you can argue is that, the underground strata is acquired. Then you need a replacement of the underground strata. But we're talking about the property you're living in. Say in a railway project, if the underground strata is acquired, it will not affect your property above ground. So you don't need to buy a replacement property to live in. Please wait for Ms. Wong to finish. Well, you need a legal analysis and not your analysis based on just common sense. If there are cases, give them to me. Well, if there are, say, in Singaporean cases, if there are Privy Council cases that underground strata is not a replacement property, do some legal analysis. Please let the DS answer. DS, we tried to explain it in paragraph 10. If Mr. To thinks it's not clear, we will elaborate. And may I ask, Mr. To, so will it actually be a case? I know that it is not likely, but we're talking about tax loss. Why am I so familiar with the definition of residential property? Because I was the chairman of a bills committee. That's why I know that when it comes to residential property, well, it's because it's so specified in the lease or the occupation permit. If the underground strata is acquired, then the residential property is acquired. And now you have this term, replacement property. And we're talking about stamp duty. Then the subject is the residential property. And that's why I will buy a replacement property. And there is no time frame, then there is no size. Well then, what if I buy a replacement property of $100 million? And then I will take you to court. And when people who have a lot of titles, they will be very happy. And that is the end of our discussion. I don't think our questions are answered. Please explain to us on paper a replacement property. Why not a corporate body? Well, if a Hong Kong PR do so in a company, well, they like to say whatever they want is for public interest, so the definition of a corporate body does not apply. I don't think that is the legal definition. Can we get a legal explanation? How come in this case the company is not treated as a corporate entity? But if Hong Kong PR buys a property with a company, then it is treated as a corporate entity. Please ask them to give us an explanation. Yes. I think the point is that this is not done of its own volition. When the property is acquired, that is the difference. Mr. Shek, point is a different one. The DS is... this is very insulting. He's an official, but he's not above everyone else. Last time they talk about one definition, and this time they talk about whether it's of their own volition. Hong Kong does not practice communism. It's a free market. Company is a company. A Hong Kong PR can hold a company, and then the property is acquired, then they buy another one. There is no need to pay BSD. Your question is very clear. But she did not think it through and just gave us some random answer. That's the end of our meeting. No other business. Thank you. Meeting adjourned.